For the past 9 episodes, we've explored what the public sees. The timelines, the theories, the gaps, the unanswered questions. But in this final installment, we shift our focus to what the state sees, what it has filed, what it has argued, and what it has chosen very carefully to make part of the official record. Because in every high-profile case, there are 2 stories. The one told in the media, and the one told in court. And while these stories often overlap, they are not the same. The court doesn't speculate, it doesn't rumour, it doesn't interpret the online noise or the personal grief. It deals in affidavits, motions, exhibits, evidence, and silence. In the case of Bryan Kohberger, the legal process has revealed both a great deal and almost nothing. The arrest affidavit gave the public its first look into what investigators believed. A knife sheath, cell tower data, vehicle sightings, surviving roommates, digital trails. It read like a roadmap, but even then, it was only a roadmap to arrest, not conviction. Since then, hundreds of filings have followed, from both the prosecution and the defense, each one telling us something different and hiding something else. Some documents are sealed, others redacted. Some were filed simply to keep evidence out of the courtroom, others to demand it be let in. In this episode, we won't speculate. We'll examine what's there in black and white, what's been filed, what's been fought, what the court has chosen to acknowledge, and what it has chosen to conceal. Because for all the noise outside the courthouse, the future of this case, and the lives changed by it, will be decided by what's on record, not what we think, but what can be shown. As our special investigative series comes to the end, this is where the official story begins. With the documents, with the filings, with the questions still waiting in the margins. This is what the court has said, and what it still refuses to say. On December the 30th, 2022, Bryan Kohberger was arrested in Pennsylvania, thousands of miles from Moscow, Idaho, and just days later, the first official document in this case was unsealed. It wasn't a confession, it wasn't a verdict, it wasn't even a complete version of events. It was a probable cause affidavit, a document signed not to prove guilt, but to justify arrest. And while it didn't answer every question, it reshaped the entire conversation. Inside its 19 pages, we were given a story. A white Hyundai Elantra spotted near the crime scene. A cell phone that went dark, then pinged near the victim's home hours later. A leather knife sheath found on a bed beside 2 victims. And a DNA sample, partial but specific, that the state said linked the sheath to Kohberger. We also learned of a surviving roommate who reportedly saw a figure clad in black leaving the house, but didn't call police for hours. The narrative was clear, and for many, it seemed decisive. But what's important to understand is this. An affidavit is not a full case. It's a snapshot, a justification, an argument made by the prosecution to establish that arrest is reasonable, not that guilt is certain. Much of what was included in that filing was already carefully curated. There were no photos, no witness transcripts, no surveillance footage, just summaries. The affidavit did not detail where Kohberger was in the days prior to the murders. It did not explain whether he had ever been in the house before. It did not provide a motive, or explore whether anyone else may have been involved. It offered a version of events, one that was plausible, based on evidence the state had chosen to present. But even within that narrative, questions emerged. If Kohberger had studied criminology, why would he bring his own vehicle, and potentially his own phone, to the scene? Why leave behind the sheath and nothing else? And why were there no other traces, fingerprints, blood, DNA, ever publicly confirmed? The affidavit did not answer those questions, because it didn't have to. It only had to meet a standard. Probable cause. Not proof beyond a reasonable doubt, not the full truth, just enough to say, this person should be arrested. We'll explain the rest later. But later, so far, has been slow. And while the affidavit remains the most detailed account the state has released, it is still a starting point, not a conclusion. A frame, not a painting. And in a case this complex, how much remains outside that frame may prove just as important as what's already inside. In the early days of the investigation, information flowed fast. Journalists, analysts, even ordinary social media users began piecing together fragments, vehicle descriptions, surveillance footage, speculative timelines, and academic records. It was chaotic, unfiltered, and often inaccurate, but it was also revealing. Then, in January 2023, the flow stopped. A sweeping gag order was issued by the latter county magistrate judge, prohibiting police, prosecutors, the defense, and any attorneys or agents connected to the case from making public statements about the investigation. No more interviews, no more press briefings, no clarification, no comment. What had begun as a highly public case suddenly became a black box. From a legal perspective, the order made sense. This is a high-stake case, one that will draw national attention at trial. And pre-trial publicity, if left unchecked, can undermine a defendant's right to a fair trial. But to many observers, the gag order didn't just reduce speculation, it amplified it. Because when official sources fall silent, the void is often filled with opinion, rumor, and conspiracy. Critics of the gag order argued that it went too far, that the public had a right to basic information, especially in a case that had shaken an entire university town. Even attorneys for media organizations challenged the order in court, calling it overly broad and unconstitutional. But their appeals were denied, and so the silence held. In the months that followed, updates came only through legal filings, dense, redacted, and often delayed. No direct statements from investigators, no updates from the families, no real-time response to online rumors, even the most harmful or misleading. This silence has served a purpose. It's protected the integrity of the case, but it's also, perhaps unintentionally, created a fog. Because when the people closest to the truth are legally forbidden from speaking, what remains is not certainty, but confusion. The gag order doesn't prove guilt. It doesn't hide innocence. It simply limits access and shifts the burden of information from the official record to the courtroom. And for now, that courtroom remains quiet. But the questions grow louder, and the longer they remain unanswered, the more power they give to the silence itself. In any criminal trial, the evidence presented to a jury is only part of the story. Behind the scenes, attorneys on both sides engage in a strategic legal dance, not just about what to prove, but what to exclude. These requests come in the form of motions in limine, formal filings submitted before trial, asking the court to limit or suppress certain types of evidence from being shown to the jury. And in the case of Bryan Kohberger, some of the most revealing details about the prosecution's mindset haven't come from what they plan to present, but from what they've asked to keep out. Among the most notable, a motion to limit references to the 911 call. The state has requested that specific details about that call, including the description of a passed-out person and who exactly made the call, be kept from the jury unless the defense opened the door. Why? Perhaps because the 911 call raises uncomfortable questions. Why was the crime not reported until nearly noon? Why was there no mention of blood, only an unconscious roommate? And perhaps, most importantly, who exactly spoke to dispatch that day? The prosecution also filed to exclude certain social media messages and text exchanges between the victims and their friends. On the surface, this may be to prevent prejudicial or irrelevant material from distracting the jury, but it also suggests that some of what exists in the victim's digital history may not support the state's narrative. It could be messages that reference unrelated conflicts, or statements that could be twisted into doubt, or simply content that opens more questions than it answers. Then there's the issue of third-party culpability, the possibility that the defense could argue that someone else may be responsible. The state has signaled an intent to restrict such suggestions unless the defense can provide clear, admissible evidence. That's standard procedure, but it also reinforces how narrowly the state wants to frame this case. One suspect, one night, one conclusion. From a legal standpoint, these motions are strategic. They're about controlling the narrative, keeping the trial focused, minimizing distractions. But from a broader perspective, they also highlight what jurors won't hear, and in some cases, what the public may never know. Because trials aren't just about truth, they're about presentation, and what's left out of a courtroom can be just as important as what's let in. So when we ask what the prosecution believes, we must look not just at their evidence, but at their silence, and the things they hope the jury never hears. Every major case has a moment when the outside world first becomes aware. For the Idaho 4 murders, that moment came at 11:58 a.m. on November the 13th, 2022, nearly 8 hours after the killings are believed to have occurred. That was when the 911 call was placed. Not by the survivors directly, but from a roommate's phone. In that call, dispatchers were told that someone inside the house was passed out and wouldn't wake up. No mention of blood, no mention of screams, no mention of a violent scene. Just a person, unconscious. By the time officers arrived, they found 4 victims, brutally murdered, and a crime scene that has since been described as one of the most violent in Idaho's history. So the question remains, what exactly happened during that call, and why did it take so long to make? For over a year, little was known. The audio was never released. The identity of the caller remained officially redacted, and speculation filled the silence. But in April 2025, a court document finally shed light on some of the mystery. In a motion filed by the prosecution, we learned that the 911 call was placed by Dylan Mortenson's phone, but that the person speaking was reportedly a friend, not a resident of the home. That friend had reportedly arrived after being summoned. The roommate had seen something and called for help, but not for emergency services. Only after the friend arrived was 911 contacted. In that call, the friend reported a person passed out, not murdered, and the prosecution now seeks to limit references to this call at trial, arguing that its content is not relevant and that the caller was not a direct witness to the crime. But for many following this case, that call is deeply relevant, not as evidence of guilt or innocence, but as a window into the timeline. Because in those 8 hours of silence, questions multiply. Why didn't anyone call sooner? What exactly did Dylan Mortenson see that night? And why was the scene described in such understated terms? One theory is shock, another confusion, another fear. Some believe a cleanup may have occurred before the call was made, an idea we've examined in a previous episode. Others suggest the survivors simply couldn't comprehend what they were seeing. There is also the matter of the friend who made the call. Who were they? Why did they describe someone as passed out in a house that had been the site of 4 homicides? And how much did they really see? What we end up with is redacted summaries and motions to keep the content from the jury, which leaves us with a chilling possibility that the first official account of what happened inside that house was not the truth, but a placeholder. A vague report of a passed-out person, spoken into the phone by someone who may not have known the full horror of what lay upstairs. Or worse, did know and said something else. We may never know, but in the silence that preceded that call, and in the vague language used when it was finally made, we're left with a chilling void, not just of time, but of understanding. And once again, the most important moment in this case arrived with a whisper, not a scream. Criminal trials are not always won with airtight alibis or explosive confessions. Sometimes they're won by challenging the very ground the case stands on. And in the defense of Bryan Kohberger, that seems to be the strategy taking shape. His legal team has not yet publicly outlined an alternative theory. They haven't claimed someone else committed the crime. They haven't even directly denied that Kohberger was near the scene. Instead, they've begun to dismantle the state's case from the ground up. Their filings suggest a multi-pronged approach. one that doesn't tell a competing story, but instead questions the structure of the one already being told. First, there's the traffic stop. The defense has scrutinized the surveillance and search leading to Kohberger's arrest. They've questioned how law enforcement tracked his car, what probable cause was used, and whether the stop itself, made in Indiana during his cross-country trip, was part of a coordinated attempt to gather surveillance without a warrant. Then, there's the DNA evidence. His attorneys have raised concerns about how the knife sheath DNA was tested, and whether the genetic genealogy method used to narrow down the suspect's pool violated privacy or lacked sufficient oversight. They've also filed motions about the trash recovered from Kohberger's parents' home, arguing that the DNA match wasn't conclusive, and that investigators never proved that the sheath was actually touched by Kohberger at the time of the crime. Next comes the cell tower data. The defense may attempt to show that the phone pings cited in the affidavit aren't precise enough to prove presence, that being in the vicinity of the house doesn't mean being in the house. There's also been scrutiny of the grand jury process, the closed-door proceeding used to indict Kohberger. His legal team has raised concerns about transparency and whether a traditional preliminary hearing would have given the defense more insight and control over how evidence was presented. At its core, this strategy isn't about disproving guilt. It's about introducing doubt. Was the traffic stop lawful? Was the DNA properly collected? Was the sheath ever touched that night? Was the phone really at the scene? Was the indictment fair? One by one, the defense is attacking the cornerstones of the state's narrative. Because if enough of those stones are removed, if the evidence becomes less certain, less direct, less reliable, then the whole structure may begin to shake. This isn't a strategy that demands a new theory. It only requires one thing: reasonable doubt. And even if a single juror begins to wonder whether the foundation of this case was built too quickly, or too quietly, or with the wrong assumptions, that may be enough to change everything. Innocence is not what must be proven. Doubt is what must be raised. And so far, Kohberger's team is aiming their argument at the very roots of what the state believes is solid ground. For all that we've seen in this case, the arrest affidavit, court filings, motions from both sides, the most important pieces may be the ones we've never laid eyes on. Because in the state of Idaho versus Bryan Kohberger, much of this case remains sealed, redacted pages, closed hearings, evidence marked for judicial eyes only. The secrecy isn't unusual. Courts often withhold sensitive material to protect due process, to preserve a fair trial, or to safeguard victims and witnesses. But in a case with such widespread public interest and such a deep undercurrent of unanswered questions, the sealed records feel like more than just procedure. They feel like walls between what's alleged and what can be seen. Among the materials that remain sealed are full transcripts of the grand jury proceedings, where Kohberger was indicted behind closed doors, details about surveillance footage from around the house and whether any was recovered from nearby residences, the complete forensic lab reports, which would show precisely how DNA and other evidence were collected, handled, and analyzed. And perhaps most crucially, any evidence that may involve other individuals, either as potential witnesses, persons of interest, or individuals referenced in digital or physical records. So what does that mean? It means the public, the media, and even many legal analysts are trying to piece together a narrative with incomplete parts. It also means that key questions about motive, timeline, and additional evidence are being debated in a vacuum. Some believe this secrecy is necessary, that premature disclosure could taint the jury pool or even derail the trial. Others argue that the silence has fueled speculation, that the vacuum left behind has been filled by rumor, conspiracy, and mistrust. What's certain is this: the story the public sees is not the full story, and the narrative that's played out in court documents so far is shaped as much by what's withheld as by what's revealed. We do not know what's in those sealed files, but we do know what their existence implies. That there's more to this case, more detail, more complexity, more context than we've been allowed to see. And when the trial begins, some of that may finally emerge, or it may stay sealed forever. Because in a system built on both transparency and protection, some truths are considered too volatile to show. And in those sealed records, somewhere behind stamped covers and judicial orders, may lie the answers that could confirm the state's entire case, or unravel it completely. Justice is supposed to be swift, but in the courtroom, especially in a case as complex and high profile as this one, time rarely moves quickly. Since Bryan Kohberger's arrest in December 2022, almost every aspect of this case has taken longer than expected. A preliminary hearing was scheduled, then cancelled in favour of a grand jury indictment. Trial dates were set, then vacated. Discovery has stretched across multiple months, and key hearings have been postponed, often at the request of either the defence or the state. To many outside observers, these delays feel suspicious. Why not move faster? Why not get to trial? But the truth is, delay is often strategy. For the defence, time is a tool. It gives them room to investigate, to challenge evidence, to file motions that could suppress crucial parts of the state's case. It also allows for expert reviews of forensic material, and it forces the prosecution to keep its arguments airtight, knowing they'll be picked apart in great detail. For the prosecution, time is also valuable. It allows for deeper preparation, for refining legal arguments, and for managing the logistics of calling dozens, perhaps hundreds of witnesses, analysts, law enforcement agents, and experts. It also ensures that no mistakes are made that could later serve as grounds for appeal. But beyond legal strategy, there's another reason this case has moved slowly. The scale. The Idaho 4 case is one of the most high-profile murders in recent American history. It involves a multi-state investigation, a mountain of digital and forensic evidence, and unprecedented public scrutiny. Every filing is analyzed, every motion dissected, every delay criticized. But inside the courtroom, judges don't operate on public pressure. They operate on process. And if either side feels that more time is needed to avoid prejudice or ensure fairness or to secure the integrity of the trial, courts will often grant it. It's not about slowing down justice. It's about preventing it from cracking under the weight of speed. As of now, no official trial date has been set, and it remains unclear whether Kohberger will face trial in 2025 or if additional motions and appeals will push it even further. To the families, this weight is unbearable. To the public, it's frustrating. But to the legal system, this is how justice is built. Slowly, carefully, and deliberately. And when the trial does begin, after all the filings, the hearings, the sealed records, and the public speculation, the goal is simple: to present a case that holds up under the weight of scrutiny. Because in a courtroom, it's not the speed of justice that matters, it's the strength of it. In the pursuit of justice, transparency is often hailed as paramount. Yet in the corridors of the courtroom, certain doors remain closed, certain documents concealed. In the case of Bryan Kohberger, the veil of secrecy is not merely a procedural formality, it's a defining characteristic. A recent judicial order highlighted a pervasive trend: the routine sealing of entire documents, often without specific justification. The court emphasized that such practices run counter to the public's First Amendment rights to access court proceedings and records. Moving forward, the court mandated stricter adherence to Idaho Court Administrative Rule 32, requiring detailed explanations for any sealing or redaction requests. This directive underscores a critical tension: the balance between the public's right to know and the necessity to protect sensitive information. Among the sealed materials are transcripts from closed hearings, including discussions on investigative genetic genealogy and motions challenging the admissibility of certain evidence. Portions of these transcripts remain redacted to safeguard personal privacy and ensure a fair trial. Additionally, the 911 call made on November 13, 2022 has been a focal point of legal debate. The prosecution sought to admit the call and its transcript into evidence, arguing they fall under exceptions to the hearsay rule, such as present sense impression and excited utterance. The court's handling of these materials reflects a broader strategy to control the narrative presented to the jury while minimizing potential prejudice. But for the public, these sealed and redacted documents represent more than legal nuances. They are missing pieces of a puzzle, gaps in a story that has captivated and confounded. As we approach the trial, the question remains, will these concealed documents eventually see the light of day, or will they remain locked away, their contents known only to a secret few? In the end, the pursuit of truth in the courtroom is as much about what is revealed as it is about what remains hidden. Because sometimes, the most telling details are the ones we are not allowed to see. We often think of justice as a story, something with a beginning, a middle, and an end. But in cases like this, justice is more like a trail, a paper trail, made up of filings, motions, transcripts, and judicial orders, each one carefully worded, strategically crafted, and legally bound. In the case against Bryan Kohberger, this trail has led us through arrest affidavits, motions to suppress, arguments over DNA, sealed hearings, and redacted transcripts. We've seen how prosecutors laid out a case built on cell data, vehicle tracking, and genetic genealogy. We've seen how the defense has responded, by questioning the chain of custody, the methods of surveillance, and the constitutionality of the investigation itself. We've heard about the 911 call, not in full, but in fragments. We've seen references to a knife sheath, to touch DNA, to search warrants executed across state lines. We've seen documents filed under seal, and transcripts scrubbed of names, dates, and meaning. We've learned how courts balance two competing principles, the public's right to know, and the defendant's right to a fair trial. And in that balance, truth often becomes selective. Because here's what the paper trail tells us. It tells us that law enforcement believes Kohberger acted alone, that a sheath was left behind, that cell tower data placed his phone near the crime scene, and sometimes nowhere at all. It tells us that a surviving roommate saw a masked figure, but didn't call for help. That a friend used her phone hours later to report someone passed out. It tells us that the prosecution believes the case is strong, and that the defense believes it is flawed. But here's what the paper trail doesn't tell us. It doesn't tell us why. It doesn't tell us how 4 lives were taken in silence. It doesn't tell us whether the scene was staged, or whether another person was involved. And it doesn't tell us what's in the sealed reports, or why certain motions were hidden from view. It doesn't tell us what the victims said that night, or what Dylan Mortensen truly saw. It doesn't tell us what was erased, what was overlooked, or what may never be revealed. And maybe it never will. Because the paper trail is not the truth, it's the legal version of it, a version shaped by rules, by timing, by strategy, by silence. And as this case moves towards trial, we may finally hear the full story, or we may only hear what the court allows us to know. Because in the justice system, truth is often redacted, and the silence between the lines is sometimes louder than the words themselves. And so as we come to the end of this journey, 10 episodes, 10 angles, 10 deep dives into the case that has both gripped and divided the public imagination, the Idaho 4. We've examined theories, we've explored timelines, we've questioned what was possible and challenged what was presented. But most importantly, we've remained grounded in one truth, that seeking understanding is not the same as assigning blame. We've looked at the layout of a house now demolished, the silence of cell phones, the possibility of digital footprints, alternate theories, and unseen players. We've explored the defense's strategy, the prosecution's filings, and the secrets still locked away behind redacted pages and sealed transcripts. Throughout it all, our goal was never to sensationalize, but to investigate, not to accuse, but to ask, not to interfere, but to inquire. Because in a case where silence has been its own character, curiosity becomes a kind of justice. As we close this final chapter of our official investigation, there's one last piece to come. In our next and final episode, we'll step back from the details and take a broader look at everything we've explored. From digital trails and DNA to unseen players and unspoken motives, we'll weigh each theory on a balance of probability, not to declare a verdict, but to reflect on what feels most plausible and what remains open to interpretation. It's not a conclusion, it's a reckoning. Join us one last time as we ask, what do we really know, and what might we never know? So as this episode comes to a close, we remind you of what remains. 4 lives taken far too soon, a town still mourning, and a courtroom that will, someday, attempt to bring answers, if not peace. Until then, we wait, we ask, and we listen. If this series gave you something to think about, we invite you to like, comment, and subscribe to the Silent Casebook. Turn on notifications so you never miss an update. This was a one-off special investigative special. For continued, in-depth coverage of the trial, we recommend the excellent work of independent journalists like Harsh Reality, whose dedication to facts and courtroom transparency continues to set a standard. You can find his channel on YouTube, and we encourage you to give him a follow. I'll add a link to his channel in the description below.